Your Honour, if it pleases the court, my name is Moodley, initials J, and I am here today on behalf of my client Simon, a 15-year-old Aboriginal charged with one count of murder. As defence counsel for the accused, I submit, Your Honour, that the evidence was obtained in contravention of statute, thus contravening public policy. The evidence carried substantial prejudicial value arising from gratuitous concurrence, to which we also contend the ground of fairness applies. Accordingly, the evidence should be excluded by way of Section 130 of the Queensland Evidence Act and the power vested in the court by Section 590 AA subsection 2 paragraph E of the Queensland Criminal Code. Public policy dictates that there is a public interest in the protection of individuals from unlawful and unfair treatment. Subsequently, the Defence Counsel asserts the exclusion of the interview due to multiple contraventions of the Police Powers and Regulations Act by the officers involved. Your Honour, we firstly turn to the most pressing issue, being the improper detention of my client for a period exceeding 8 hours, breaching Part 2, Division 3, Section 403, Subsection 2 of the PPRA. There is additionally nothing to evidence an extension of the detention period within this set division. Section 403, Subsection 5, Paragraph A dictates the detention period began at 10 a.m. and my client was held until 7:05 p.m., creating a total detention period of 9 hours and 5 minutes. This constitutes an immediate breach of the section. Compounding this with Section 404, Subsection 1, Paragraph E, the officers failed to take into account my client's age, which would have warranted a shorter detention period. The next breach falls within Part 3, Division 3, Section 420, Subsection 2, Paragraph B of the PPRA. This stipulates that when questioning an Aboriginal or Torres Strait Islander member, the officer must arrange for a legal aid representative to be present. Your Honour, there is no record of the phone call being made, which suggests that it was never made. Your Honour, in any reality, if the officers made the call, it will be shown either on their dialogue, their phone company's dialogue, on the relevant telephone, or a witness evidence from the legal service itself. The officer knew that Simon was of Aboriginal background as he notified him that he would specifically contact the Aboriginal or Torres Strait Islander legal aid. Therefore, the officer was in immediate breach of this section. Your Honour, the defence does acknowledge that our client was not of adult age as stipulated in Section 420, Subsection 1, Paragraph B. However, we do contend that this section should compound with Section 421, Subsection 2, Paragraph A to create a more onerous duty on the officers. This section of the PPRA requires a child, Simon, to speak to his support person, his mother, prior to questioning. Subject to contrary evidence, the officers did not facilitate this right. It is likely at this point of the interview that the officers were aware of Simon's age due to the relevant identification processes followed at a police station. Your Honour, the Defence Counsel now will turn to two cases in Bunnings and Cross and the Crown and Island to assist your exercise of judicial discretion against the recording. In accordance with the Crown and Island, this evidence was improperly obtained by way of unlawful acts and was obtained at too high of a price. Police must not think that they can behave like this towards citizens when still investigating potential indictments. It is a matter of public policy to ensure that these practices are not encouraged, which can have the effect of wrongful convictions, as seen in our case. May I direct the Court to now the 5 factors enunciated by Justices Stephen and Aiken in Bunnings and Cross to inform your Honour's discretion in exercising your vested judicial discretion to exclude the evidence from the Court. Firstly, it is apparent that the conduct did not result from a genuine mistake. It was rather a deliberate breach of multiple sections and willful non-compliance by the officers with their obligations when performing their responsibilities under Section 7, Subsection 1 of the PPRA. The officers deliberately detained Simon for 3 hours while searching, following another 6 hours at the station, breaching this statutory obligation. There were many alternatives available to the officers, however, they chose this option. The officers additionally willingly failed to contact the legal service prior to the interview. Secondly, Your Honour, we contend that although the evidence was vital to the Crown's case, it was not of perishable nature. It is not particularly cogent as well due to the factors of gratuitous concurrence and the way in which the evidence was obtained. Thirdly, Your Honour, there was no evidence that the police's actions were a genuine response to pressing circumstances. They rather appeared to be cutting corners to ensure the indictment remained against my client. Detaining Simon for an extra period of time is not a pressing circumstance. The pressing issue here was rather the contact of the legal aid before the interview due to the potential cultural impacts and effects. Fourthly, Your Honour, the Defence Counsel does acknowledge the gravity of the charge is severe and this may affect the evidence's inadmissibility. However, Your Honour, the conduct gave breach to 4 sections of the PPRA aforementioned. The purpose of the Police Powers and Regulations Act is to prevent or regulate police conduct in terms that the evidence obtained is obtained properly and to prevent the abuse of institutional power against individual members of the public. This is a textbook example of the exact kind of conduct the PPRA seeks to prevent. Your Honour, all factors present a strong case for you to exercise the court's discretion to exclude this evidence on the ground of public policy. Your Honour, the Defence Counsel would now like to turn your attention to the fairness discretion, otherwise known as the Christie discretion, which was accepted in the High Court of Lee and Hassler. Your Honour, in light of the Crown and Christie, although critical to the Crown's case, I ask that you exercise your judicial discretion to exclude this evidence in accordance with Section 130 of the Evidence Act. This is on the ground that it would be highly prejudicial to the prospect of a fair trial to my client. Simon was a vulnerable witness in a stressful situation in which the PPRA is made to protect against. Your Honour, I believe our client was unfairly victimized by the actions of the officers. He was likely to be so far intimidated, being 15 years of age and in absence of a lawyer, as to be a disadvantaged witness due to the cultural impact of gratuitous concurrence. This phenomenon occurs when an Aboriginal person is questioned by someone in authority and they seem to affirm or agree to everything that is put forward by these people, even if it is incorrect. Arising from this, and as very blatant, this can prima facie make the evidence unreliable, less cogent, slightly probative, but highly prejudicial and unfair to our client. Your Honour, we have submitted 2 grounds in which we ask for you to take into account when exercising your discretion as to the admissibility of this evidence to the Crown's case. Thank you.